जम्मू आ गए, दिल्ली आ गए, अलग अलग जगह पे आ गए, और अभी सरकार उनको कह रही है कि फिर से हम
मेरी बात समझ गए? क्या सबके साथ मर्डर हो जाता है? क्या सारी बहुएं जला के मार दी जाती
It is the sir, during my LLB days, we have completed the IPC, but now we have BNS. What should we do, sir? Whether we should go with the IPC or BNS, or sir, if there any similarity, क्या अब हमें पूरा BNF दोबारा पढ़ना पड़ेगा? ये क्वेश्चन जो है प्यारे बच्चों, एक बहुत ही इंपॉर्टेंट क्वेश्चन हमारे सामने आता है और जिसको हमें समझना रहता है। ठीक है, तो इसी को आज हम डील करने की कोशिश करेंगे। फर्स्ट ऑफ ऑल आई वुड लाइक टू टेल यू व्हाट इज द सिनॉप्सिस ऑफ आवर क्लास। ठीक है, क्या हमें करना है, क्या नहीं करना है, इसको हम समझेंगे। ठीक है, तो देखो क्या करेंगे आज की क्लास में। मैं हमेशा अपनी क्लास का सिनॉप्सिस देता हूं। फर्स्ट ऑफ ऑल वी विल डू द कॉम्परेटिव एनालिसिस बिटवीन द आईपीसी एंड बीएनएस, एंड वी विल डिस्कस द इंपॉर्टेंट चेंजेस मेड in the BNS. Number 2. Number 3, after that we will cover a topic of your choice कि सर हमें ये पढ़ा दो, सर हमें ये समझा दो, उसको हम पूरा कवर करने की कोशिश करेंगे। ठीक है, ये काम हम आज की क्लास में करने वाले हैं। पूरा का पूरा एक टॉपिक आपका आज तैयार हो जाएगा कम से, बिकॉज आई थिंक कि एटलीस्ट जो है ये यू शुड यूटिलाइज योर 1 आवर जो आप मेरे साथ बिताने वाले हैं। तो दिस इज द सिनॉप्सिस ऑफ द क्लास। ओके, so dear students, we were discussing that there is lots of similarity between the BNS and Indian Evidence Act. Lots of similarity between the Indian Penal Code and BNS. Sir, as you all know, for the important topics there is a no changement. As far as my opinion concerned, there is a 90% similarity between the IPC and the BNS. There is a 90% similarity between the IPC and the BNS. 90% similarity, at least 90% similarity between the IPC and the BNS. Because I'm not going to the punishment provision, I'm not going about the slight change. We are going to the basics of the IPC, mainly the definition of the crimes especially. Like there is no changement in the definition of murder, there is no changement in the definition of theft, robbery, extortion. There is no changement in the rape, definition of rape, common intention, common object, common elements of the crime तो हमेशा सेम ही होते हैं। हाँ, किडनैपिंग में थोड़ा चेंज, बहुत स्लाइट चेंज है। सो एज फार एज द बीएनएस इज कंसर्न, it is almost similar to the IPC. Yes, number is changed, index is basically changed. It is now well organized act. This is a well organized code. So there is a 90% similarity between the IPC and BNS, 90% similarity. Okay, so no need to worry ki sir what should we do, the definition of murder is same, culpable homicide is same, theft, extortion, robbery, everything is same. So why you are worried about it? Number 1. So number 2, ki sir if there any changement, yes, there is a substantial sections which is removed from the BNS. There is a very important sections which inserted into the BNS, like section 124A, sedition, it is no longer in the BNS. Like section 377, which was declared unconstitutional in the very leading case Navtesh Singh Johar versus Union of India. Like 124A of the IPC, it is no longer, ये नहीं है BNS में। ठीक है, section 377 of IPC, that is the unnatural offenses, ये भी नहीं है BNS में। Why? Because in the very leading case Navtesh Singh Johar versus Union of India, in that particular case it was declared unconstitutional. It was declared unconstitutional. आगे 497, which was very important section, that was the adultery. Adultery is still ground for the divorce. Adultery is still ground for the divorce, but it is no longer crime, because in the very leading case Joseph Sain versus Union of India. In that particular case, it is declared unconstitutional. So we removed section 377, 497, 324A, 124A from the BNS. Other than this, attempt to suicide, that is the section 309, it is no longer crime. It is also removed from your BNS. So there is a several sections removed from your BNS, but there is a very important section which inserted into your BNS. Okay, so this is the change, but it is not so important कि क्या चेंजेस हैं, बट ये जरूर है कि बहुत ज्यादा घबराने वाली बात नहीं है आपको, ठीक है। बहुत स्लाइड चेंजेस हुए हैं और उनको हम देखते हुए आज की क्लास में चलेंगे। और इसके अलावा हमने ऑर्गेनाइज कर दिया है। द ऑफेंसेस अगेंस्ट द वुमेन वाज स्कैटर्ड इनटू द एंटायर आईपीसी। रिमेंबर 354, 354 A, B, C, D. Are you getting my point or not? 375, 376, 509. What it means? Offenses against the woman is scattered in the entire IPC. What we did basically, all the offenses against the woman collected, clubbed into the chapter 5 of the BNS. Chapter 5 of the BNS. Okay. Offenses against the woman and child clubbed into the chapter 5. Other than this, there is a several new sections like organized crime, petty organized crime, terrorism act, section 111, 12 and 13. There is a several new sections which is inserted into your BNS. Okay, so there is a enhancement of the punishment, but we introduces a new type of punishment, that is the community service. It is very important. According to IPC, there was a 5 type of punishment. According to the IPC, there was a 5 type of punishment. According to the IPC, there was a 5 type of punishment, but now you have 6 type of punishment. 5 is quite similar, 6th is community service. Sir, what if the community service? Community service is a new type of punishment which imposed on you if you commit any offense which is petty in nature. What it means, sir? It means for every small petty offense, no need to send the offender in the jail, no need for the imprisonment. What it means? There's a new type of punishment, community service. Community service means service of the community. Service of the community without any remuneration as a punishment. This is a new type of punishment. This is the 6th type of punishment. So according to the IPC, there was a 5 type of punishment, but according to the BNS, there is 6 type of punishment. What? Number 1, death. Number 2, life imprisonment. Number 3, imprisonment. Number 4, forfeiture of property. Number 5, fine. And number 6th is the community service. Look, Law Commission of India 1997. Which year? Look, Law Commission of India 1997 and Law Commission of India 1997 and 2002 suggested to introduce the new type of punishment that is known as community service. Suggested to introduce a new type of punishment which is known as community service. Suggested to new type of punishment which is known as community service. But we don't introduce it. Okay. There is a loophole. It is still unclear who will monitor this type of punishment, that is the community service. हॉलीवुड मूवीज में आप अक्सर देखते होंगे जज साहब इसी तरह की पनिशमेंट सुनाया करते थे, बट दिस इज द न्यू प्रोविजन फॉर अस. ओके, so we have a new type of punishment, that is the community service. We introduce some new sections. Okay, we make the changement. There is a section 69 which makes the any deceitful means माने there is an intent to deceit for the sexual intercourse that will lead to a punishment. That is section 69. That is very important, which is in the news. There is section 3062 which provides the very severe punishment, higher punishment if you run away from this place soon after the death, which is led by the negligently or rashly, without informing the police or magistrate. But this section is suspended, it is not enforced right now. This is the only section. So there is a several changement made in the BNS, but that changes are very slight changes. It is not, as for the judicial service aspirant, that is not so much tough. It is important but not tough. और प्यारे बच्चों, जो पुराने बच्चे थे उनको तो सारे सेक्शन याद थे. अब यू आर दी एस्पिरेंट, न्यू एस्पिरेंट, बिगिनर, आपको तो सेक्शन याद करने थे और पुराने को सारे याद थे. तो दिस इज अ ब्लेसिंग इन डिस्गाइज फॉर यू मैन, कि उनको भी अब याद करने पड़ेंगे, अब आपको भी याद करने पड़ेंगे. दिस इज अ इक्वल प्लेइंग फील्ड नाउ. आर यू गेटिंग माय पॉइंट और नॉट? जो पुराने एस्पिरेंट थे उनको तो सारे याद थे कि नहीं थे? पुराने एस्पिरेंट थे उनको तो सारे याद थे. अब आपने क्या करना है? कुछ नहीं करना. अब आपको बस, अब आपकी भी वही पोजीशन हो गई है ना. और देयर इज अ टू स्टेट्स वेटिंग फॉर यू, यूपी उत्तराखंड. यूपी इज कमिंग विद a very huge vacancy for the UP judicial service examination, as well as the UP prosecution officer examination, UP judiciary, as well as the UP APO. दोनों की वैकेंसी जो है एकदम से आप ही के पास आ रही है. नाउ वी आर कमिंग टू द अवर पॉइंट, कि जो हम क्या करने वाले हैं, बेसिकली एक टॉपिक आपकी पसंद का पूरा कवर कर दें ताकि एक टॉपिक तो खत्म हो जाए. इन दिस क्लास वी विल डिस्कस अ वेरी इंपॉर्टेंट टॉपिक दैट इज नोन एज द प्राइवेट डिफेंस. In this class we will cover a very important topic, that is the private defense, and I will tell you ki where it was earlier embodied, especially in your IPC. ठीक है. और we will do the comparative analysis कि sir, is there any changes made between the IPC and BNS or not. We will cover all the questions. We will cover this topic along with the case laws, and I am promising you, you will remember all the sections in this class. You will remember all the sections in this class. Okay. So now I am telling it to you, dear, we are going to discuss the private defense. What we are going to discuss? We are going to discuss private defense. Chapter 4 of the IPC. What? Chapter 4 of the IPC deals with the general exception. Now this is the comparative chart. This is the IPC and this is the BNS. This is the IPC and this is the BNS. Chapter 4 of the IPC deals with the private general exception. Which the name of the chapter is general exception. ठीक है. General exception. Dear students, general exceptions. So in this chapter, we are going to discuss the chapter 4, which is now chapter 3 of the IPC. We are going to discuss the chapter 4 of the IPC, which is now chapter 3 of the BNS. ठीक है. Chapter 3 of the BNS. Look dear, it is quite simple. It is quite simple from section in your IPC. Remember, for your kind attention, remember that of the chapter section 76 to 106. What we did actually in your BNS, it is section 114 to 44. 114 to, sorry, 14 to 44. Now we are going to discuss the general exception, this particular chapter. Today it will quite clear for you what is the private defense along with these sections. So now we are going to discuss this topic. इसकी तो बात ही नहीं कर रहे, बस इसलिए बताया क्योंकि it was in the IPC. This particular chapter divided into the two categories: excusable and justifiable. Excusable and justifiable. From section 34 to 44, that is the private defense, and from section 14 to 33, that is related to the excusable, and that is, yes, such point is known as private defense. Second part. So now we are going to discuss 34 to 44. This is the private defense. Look at your Bayer Act from section 34 to 44. ये क्या हो गया, इसको लगाओ. Wait. हाँ. Look at me. look at me, look at me, look at me, look at me, look at me. This is the topic. That is the topic. From section 34, from section 34 to 44, that is related to the private defense. That is related to the private defense. Earlier it was, देखो याद करो, section याद करो, that was section 96 to 106. How many sections were there? 10. Now 34 to 44. How many sections are there? 10. What it means, बच्चे घबराने की जरूरत ही नहीं है. Look at me. यहां से ये पूरा बल्क उठाया गया और उठा करके यहां शिफ्ट कर दिया गया. ये पूरा का पूरा ग्रुप उठाया गया from 196 to 106. The entire topic that was the private defense picked up and put in the chapter 3 of the BNS from 34 to 44. Look at me. 76, sorry, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105 and 106. It is quite similar. No need to worry. The entire IPC chapter 4 topic private defense general exception from 96 to 106 picked into the and put in so and so manner. What it means बच्चे? It means no need to worry. मैंने क्या कहा था स्टार्टिंग में? There is a 90% similarity between the IPC and BNS. What I told you earlier? That there is a 90% similarity between the IPC and BNS. Look at the board. Today we are going to discuss one important topic. Definitely you will get at least one question in your mains and two questions in your prelims from this topic. This is the importance of this topic. So for your kind attention, for your introduction, no need to worry, that is the section 96 to 106, almost 10 sections picked and put into the chapter 3 from 34 to 44 of your BNS. No changement, not even in the order of the sections, not even in the sequence of the section, as it is they pick and put here. Okay. So first of all, whether it is embodied in the chapter 3 of the BNS. So now we are going to discuss what is the private defense. Just listen to me carefully and it is important. Dear students, Jeremy, have you heard about the name of the Jeremy Bentham? Jeremy Bentham defined the utility of the right of private defense. बड़ी अच्छी बात जेरमी बेंथम ने कही कि जेरमी बेंथम कहते हैं कि राइट ऑफ अ डिफेंस especially right of a defense is the absolutely necessary. Why so? उन्होंने कहा कि vigilance of a magistrate can never make up a vigilance to the each and every individual. मतलब if we are fitting in a room, we are fitting in this place, अब हमारी तुम्हारी लड़ाई हो जाए, मैं तुम्हें पीटने लगूं, तो anyone can save you? No. Any authority can protect you? No. Only the you can resist the force imposed on you. So this is very important given in the definition of the Jeremy Bentham ki this is the right and need of the right of private defense. प्यारे बच्चे, right of self defense is the basic human instinct. Even right of private defense is recognized all over the world. Even if you remember, प्यारे बच्चे, यूपी जुडिशरी के लिए बड़ा इंपॉर्टेंट है यूएन चार्टर. इफ प्यारे बच्चे, ऑल ओवर द वर्ल्ड, even in the United Nations Article Charter Article 51, United Nations Charter Article 51, UN Charter Article 51 recognize this particular chapter, recognize this particular section, recognize the utility of the right of private defense not only for the state but also for the state. State means countries. स्टेट मीन यानी कि अगर हमारी कंट्री पे कोई अटैक करेगा तो वी हैव आर्टिकल 51, वी कैन रेजिस्ट. हमें किसी से पूछने की जरूरत नहीं है. तो जब स्टेट को इंडिविजुअली, स्टेट को राइट ऑफ प्राइवेट डिफेंस मिला हुआ है तो हम तो इंडिविजुअल हैं, हमें क्यों नहीं मिलना चाहिए. बट we are discussing the what if the right of private defense. First of all, right of private defense is only for the defense rather than aggression. We must keep some rules in our mind before starting this topic. Number one, this is a rule of defense. This is only for defense, not for the aggression. Number one. What I told you? This is only for defense, not for aggression. ठीक है. Number two, right of private defense is available body of your own and body of the others. अगर मुझे कोई मारेगा तब भी आपके पास right of private defense है. It is not necessary कि I should be your family member. Number two. Number three, right of private defense is available to the body as well as the property. Property of both kind, movable, immovable, दोनों. Number three. Number four, right of private defense is only for the defense, not for the aggression. Right of private defense is right of defense, not for the punitive purpose. So there is the limitations of this right. आप जरूर आगे बढ़कर इसको एक्सरसाइज नहीं कर सकते हैं. So प्यारे बच्चे, तो why we need the right of private defense? एक सेक्शन याद होगा. We will discuss lots of case laws, or that is very important. You will get that cases in your examination too. Okay. So first of all, I have to introduce this topic. So प्यारे बच्चे, self help is the first rule of private defense. Self help is the first rule of criminal law basically. भाई हम अपनी हेल्प नहीं करेंगे तो हमारी हेल्प कौन करेगा? बेंथम ने एक बुक लिखी, प्रिंसिपल ऑफ पेनल लॉज. ये यूपी में बहुत पूछी जाती है. विच बुक्स? प्रिंसिपल ऑफ पेनल लॉज. उसमें जो मैंने बात बोली कि मजिस्ट्रेट का विजिलेंस आपको हर समय हर सिचुएशन में प्रोटेक्ट नहीं कर सकता. ठीक है. बेंथम ने एक बुक लिखी, प्रिंसिपल ऑफ पेनल लॉज. उसमें इन्होंने प्राइवेट डिफेंस की इंपॉर्टेंस को डिफाइन किया. और दैट इज देयर इज अ वेरी इंपॉर्टेंट केस, दैट इज द मुंशी राम versus Delhi administration. Which case? Munshi Ram versus Delhi administration. Munshi Ram versus Delhi administration. Munshi Ram versus Delhi administration. What happened in this particular case? Munshi Ram versus Delhi administration. जब से जस्टिस के.एस. हेगड़े, which justice? Justice K.S. हेगड़े. Justice K.S. हेगड़े प्यारे बच्चे emphasize the importance of right of private defense. Basically, in this particular case, Honorable Supreme Court emphasized the importance of private defense. Justice K.S. हेगड़े said that right of private defense serves the social purpose. क्या बोला उन्होंने? Right of private defense serve the social purpose. प्यारे बच्चे, इन्होंने कहा कि देयर इज नथिंग मोर डिग्रेडिंग फॉर ए ह्यूमन स्पिरिट देन टू रन फ्रॉम द फेसिंग द पेराइल. मतलब ह्यूमन स्पिरिट के लिए इससे बुरा कुछ नहीं हो सकता कि वो मुसीबत को देखकर भाग जाए, फेस करने की बजाय. तो इन्होंने कहा कि सोशल जस्टिस को सर्व करता है, सोशल पर्पस को सर्व करता है राइट ऑफ प्राइवेट डिफेंस. तो दिस इज द ऑब्जेक्ट एंड इंपॉर्टेंस ऑफ द राइट ऑफ प्राइवेट डिफेंस. इसका नेचर कैसा है? ये नेचर कैसा है कि व्हाट अबाउट द नेचर ऑफ द राइट ऑफ प्राइवेट डिफेंस? तो इन द केस ऑफ देव नारायण वर्सेस स्टेट ऑफ यूपी, विच केस? इन द केस ऑफ देव नारायण वर्सेस स्टेट ऑफ UP. In the case of Dev Narayan versus state of UP, it was quite clear, Supreme Court discussed about it, it is a preventive right, not a punitive. Right of private defense is for the prevention, not for the punitive purpose. For that purpose, there is a state. Super important thing. Right of private defense is basically a preventive right, not a punitive right. Right of private defense is a preventive right, not a punitive right. Okay. Right of private defense is a preventive right, not a punitive right. Okay.
Subscribe for more content.